and its current status. Thus, we have invited Professor Melody McKenzie from the William S. Richardson School of Law to review this history with us before we begin the discussion. Professor McKenzie will give a short 10-minute presentation on the Public Land Trust. After that, we will hear from Representative David Tarnas from House District 7, which is North Kona and North and South Kohala, and other guests. We invited several legislators who supported House Bill 499 to speak, and Representative Tarnas was the only one who accepted the invitation. So we thank you for bringing your mana'o to this discussion. After that, we will hear from 3 Native Hawaiians who oppose House Bill 499. There's a little bit of rearrangement and reassignment of speakers. The first speaker will be State Representative Lynn DeCoit. She will speak first because she needs to leave between 6:30 and 6:45. The second speaker will be from the Native Hawaiian Legal Corporation. It will be David Kuhio Plaza, the head of litigation and the main advocate with the legislature, as well as with meetings with the governor on HB 499. Then we will hear from former Governor John Waihee III, who will bring it all together, what all the speakers say, and leave us with some words of wisdom as we end our workshop or end the presentations, but then we will have an open question and answer period. So feel free to post your questions in the chat box. We received some from email, which I will ask everyone about, or put it out there for answering. And with that, let's start with Professor Melody McKenzie.
Okay, is my screen being shared? Does it show up?
I don't see anything on your screen.
Okay, let me try this again. Voila. Okay, there.
Okay.
Is it up?
It's
Yes.
up.
Yes.
Okay.
So
And
if
I
you
will
put it to full screen, then we could see just
get
the-
it too. Yeah, got it.
Looks good.
Okay. Thank you so much. Mahalo for inviting me this evening. I'm going to try and get through this in 10 minutes, but there is a lot to cover. So I begin with the Olelo No'eau, born with the land, born with the chiefs, born with the people, showing our connection to our Aina. And that is really what this is all about, our connection to our Aina. So a kind of roadmap of my presentation today: the Public Land Trust, the government and crown lands of the Hawaiian Kingdom. I'm going to do a really short history, discuss the issue of sale or alienation of trust lands, which has been of major import in the past. And then if we have time, bring up 2 other issues: revenues to OHA and the state's duty regarding trust lands that's illustrated in the Pohakuloa case. So the crown and government lands of the Hawaiian Kingdom. In the Mahele process, that is the process whereby which the Hawaiian Kingdom ended up with a kind of hybrid system of fee simple title. In that process, Kamehameha III put aside almost 2.5 million acres of land. And then he divided that land between the government and himself. So for the government lands, about 1.45 million, he set apart to the chiefs and people as the lands of the Hawaiian government, subject always to the rights of tenants. Now remember, at this time in 1848, all awards were given out subject to the rights of Native Hawaiian tenants. The crown lands, Kamehameha III kept for himself. He reserved them as his own private lands to have and to hold to himself, his heirs and successors forever, again, subject to the rights of tenants. So this is the genesis, the beginning of the Public Land Trust. I'm jumping ahead to 1893 and the overthrow of the Hawaiian Kingdom. As we all know, with the support of the US military. And in 1894, the Republic of Hawaii is formed. It controls already the government lands through the overthrow process. and it confiscates the crown lands in its constitution. And it declares that those crown lands are deemed to be free of any prior trust. During the kingdom period, it was clear that the crown lands were the lands of the crown and should be used and held in trust for the crown. But this provision basically, deems that prior trust irrelevant. In 1895, the Land Act combines the government and crown lands into the public lands. And in 1898, as we all know, Hawaii is annexed to the US by joint resolution rather than through a treaty process. Okay, so through the annexation, the joint resolution, and then the Organic Act, the sovereignty of the islands, and about by that time, 1.8 million acres of government and crown lands are ceded by the Republic to the United States. Now, during the kingdom period, lands were sold, crown and government lands were sold. So at the point of annexation and the Organic Act, there's about 1.8 million acres left. The income and proceeds are supposed to be utilized for the benefit of the inhabitants of the Hawaiian Islands for educational and other purposes. That language is confirmed in the Organic Act, which sets up the territorial government. And again, crown lands are deemed to be free of any prior trust. We're all familiar with the Hawaiian Homes Commission. I just thought I would mention this. About 203,500 acres of the government and crown lands are set aside for the homestead program. Jumping ahead again to 1959, Hawaii becomes a state. Really important provisions in the State Admissions Act. As a compact with the US, the state has to adopt the Hawaiian Homes Commission Act in its constitution. And then the United States transfers to the state primarily through Section 5B of the Admissions Act, about 1.4 million acres of those government and crown lands, including the Hawaiian homelands. But some lands, about 375,000 acres, are actually kept by the US government under other provisions of the Admissions Act. And other lands are leased to the US for 65 years at $1 a year. Okay, so this is the basis of the public land trust. The 1.4 million acres of government and crown lands, including the Hawaiian homelands. Section 5F of the Admissions Act says that these lands and their income shall be held by the state as a public trust for support of the public schools, betterment of the conditions of Native Hawaiians, development of farm and home ownership, making of public improvements, and provision of lands for public use. Now, in 1963, there is actually a federal law that's passed because the US had kept lands pursuant to Section 5C and 5D of the Admission Act. This act tells the federal government if any of those lands become surplus, as well as US lands on Sand Island, they should be returned to the state of Hawaii. The one part that was accepted from that is anything in the national parks is not subject to return to the state. The lands then become part of the public trust established by the Admissions Act. And since 1964, about 30,000 acres have been returned to the state, but this includes the 28,000 acres on Kaho'olawe. So now there are about 115,500 acres that are eligible for return under this law. Jumping ahead, 1978 Constitutional Convention. Here are some of the major players, and you'll recognize this guy over here, John Waihee. Okay, so for our purposes, the major provisions we want to look at are Article 12, Section 4. The lands transferred to the state pursuant to Section 5B of the Admissions Act, excluding the Hawaiian Homes Commission Act lands, are held as a public trust for Native Hawaiians and the general public. So this is a clear statement of the trust for Native Hawaiians and the general public. Also, the Office of Hawaiian Affairs is created, and There's a provision, Article 12, Section 6, that says OHA should administer the income and proceeds from a pro rata portion of the trust revenue. Okay, so I'm jumping ahead again. We're going to 1993. This is, as you all know, 100 years after the illegal overthrow of the Hawaiian Kingdom, and the US issues an apology. And the apology has some incredible language. For instance, it says the government, crown, and public lands of the kingdom were transferred without the consent of or compensation to the Native Hawaiian people or their sovereign government. And the indigenous Hawaiian people never directly relinquished their claims to their inherent sovereignty or over their national lands to the United States. So this is an admission by the United States, not only of its role in the overthrow, but that the Hawaiian people never directly relinquished their claims. So as a result of that 1993 apology resolution, and there were similar state legislative acts recognizing the unrelinquished claims of the Native Hawaiian people, OHA and some individual plaintiffs actually brought a lawsuit trying to stop the sale of these trust lands on Hawaii Island and on Maui. They argued that the sale would reduce trust revenue and lands, and those lands wouldn't be available for any reconciliation effort. And Pua Kanakaole Kanahele was one of the people who testified at that, and she stressed the need of our people for land to live on. That's our foundation and our relationship to the Aina. So this went to the Hawaii Supreme Court, and amazingly, and an unanimous court put a moratorium on the sale of any of these trust lands. The court said, the resolution by itself doesn't require the state to turn over the ceded lands to Native Hawaiian people, but it acknowledges the unrelinquished claims and plainly contemplates a future reconciliation with the United States and the state. And therefore, it gives rise to the state's trust responsibility to preserve the corpus of that trust until such times as the unrelinquished claims of the Native Hawaiian people have been resolved. Unfortunately, the administration at the time, this was the Lingle administration, decided to take this up to the US Supreme Court. And in a unanimous decision, the US Supreme Court said the provisions in the apology resolution are conciliatory. It doesn't change substantive law. And they remanded the case, they sent the case back to the Hawaii Supreme Court saying, but there may be a basis in state law, and that's for the Hawaii Supreme Court to decide. But under federal law, we see there's no basis for this moratorium. So lots of protests at the time, lots of uncertainty as what would happen. And so eventually there was a resolution reached with the legislature and the state. And it's set out right now in HRS 171-50, C, and 171-64.7. So to sell or gift to alienate trust lands requires a 2/3 majority vote of both houses. Land exchanges require a simple majority. Agencies have to determine whether the lands are trust lands, provide information, a detailed summary, give OHA 3 months notice before legislative session. And if there's a sale of the lands or gift of the lands, the agency has to hold an informational briefing in the community where the land is located. And I point all of this out to you to show you how important even the legislature recognizes that Aina, how important it is to our community. Now, I think I have just a few more minutes. I just want to talk about two other major issues. One is trust revenue to OHA. You'll remember that the Constitution says that OHA should receive a pro rata share of the revenue. And the legislature set that at 20% in 1980. There's a lot of cases about this. And in 2006, there was actually somewhat of a settlement. The legislature set an interim measure of $15.1 million that OHA would get annually with a back payment. And then in 2012, there was a settlement of all claims up until that point. OHA received 10 parcels of land in Kaka'ako, valued at about 200 million for the back revenue due to OHA. But the amount OHA currently receives in lieu of any actual pro rata share of the income and proceeds is set at 15.1 million annually. So no matter what the income and proceeds are that the state receives from the public land trust, OHA still only gets $15.1 million annually. So that's an issue that comes up before the legislature almost every year. I want to show you the lands in Kaka'ako, since that has also been a major issue this year with regards to OHA's request to be able to actually utilize lands. These are the lands. This over here, the big building right here is the Burns School of Medicine, just to give you some perspective. Okay. And then the other major issue, my last major issue, DLNR leases lands to the US for $1 a year for 65 years. Not $1 a year, I'm sorry, 65-year lease, $1 total. This lease expires in 2029, and there are a number of other leases that do as well. So in 2018, there was a lawsuit that was brought. Native Hawaiian Legal Corporation actually represented the plaintiffs, Kuching and Anti-Max Kaholi and the Judge Gary Chang basically said DLNR breached its trust duty to Malama Aina with respect to the lands the state leases to the US Army. And when it went to the Hawaii Supreme Court in 2019 in a landmark case, our Supreme Court said our Constitution places upon the state duties with respect to these trusts, much like those of a common law trustee, very high fiduciary trust responsibility, an obligation to protect and preserve the resources. And so the Hawaii Supreme Court basically said the state has a trust duty to reasonably monitor the property, including monitoring for the lessee's compliance with the terms of the lease that protect the property. This is an ongoing issue. And because the lease ends in 2029, and there are other areas of our state, about 30,000 acres, I think in total, that the federal government has under these kinds of leases, and they all come up in 2029. So with that, I'm going to conclude. He ka'aina, he kawa ke kanaka. Land is a chief and man is its servant. I also want to point out to you this public land trust information system. It's something that's being built by DLNR right now. It's been operational for about 2 years. I strongly suggest that you go and look at it. You can look at any parcel of land in the state and it will tell you its status as trust lands. So that's it for me. And thank you so much. I will be around if there are questions later.
Mahalo, Professor McKenzie. Now we will hear from Representative David Tarnas.
Mahalo. My name is Representative David Tarnas. I am the chair of the House Water and Land Committee. And in that position, I've got a responsibility to deal with all land use policies in the state. And so when I started this year, I looked back at the various issues that have come before the Water and Land Committee over the years. And one of the major ones has been how to best manage our public land trust and how to be able to support DLNR to do their job in managing the land trust so that we can get the 20% of revenue to OHA as indicated in Act 178, as well as the 30% of share of revenues from former sugarcane lands to the Department of Hawaiian Homelands. And after the funding goes to OHA and to DHHL, the remaining lease revenue from state land leases go to what's called the Special Land and Development Fund. And that Special Land and Development Fund is an important source of revenue that pays for the DLNR Land Division, the Office of Conservation and Coastal Lands, the Engineering Division, Dam Safety and Geothermal Programs, as well as the budgets of many other offices and divisions within the agency. And so my goal is really to strengthen DLNR's capacity to responsibly manage the public trust lands. HB499 is intended to apply to less than 1% of the 1.4 million acres of public lands managed by DLNR. HB 499 does not apply to any lands that are leased by the University of Hawaii. It would not confirm this with DLNR, that no lease to the federal government, including for military purposes, shall be extended pursuant to HB 499. So Pohakaloa or any other military leases would not be something that could use the provisions under HB 499. So I want to assure everyone about that. The reason why 499, I believe, is important is that many of the leases for commercial, industrial, resort, mixed use, and government properties on public land statewide may be nearing the end of their lease terms, and they're faced with uncertainty about their future. So the lessees really have very little incentive to make major investments into infrastructure improvements and ensure the long-term maintenance of the facilities, resulting in deterioration of the infrastructure in these properties. And most of the lessees and the users of the public lands under the management jurisdiction of DLNR that would apply for any extension under HB 499 are locally owned small businesses with employment base in Hawaii. For example, half of the revenue coming in from these public land leases comes from Sand Island, the industrial area in Sand Island. About $9 million per year comes in from those industrial land leases on Sand Island. So it's, I believe, in the state's interest to cultivate an environment that supports investment into the economy, job stability and growth, and that HB 499 would support these objectives by requiring, in exchange for a lease extension, substantial investments must be made by the lessee on the state lands, and they're prohibited from selling or assigning the business lease for at least 10 years. Now, the approval of a lease extension shall be subject to a finding that the extension supports Hawaii's economy and provides economic and job stability or growth to support everybody in Hawaii. The approval of the lease extension must be subject to a finding that the leased property is best suited for commercial, industrial, or resort purposes, or that it or mixed use purposes that benefits Hawaii's communities, including Native Hawaiians. As I mentioned, no lease for astronomy on Mauna Kea shall be extended pursuant to this bill. No lease by the federal government for military purposes shall be extended pursuant to this bill. But and it's important to recognize that any leases that had been sold within the last 10 years would not qualify for any extension under this bill. Approval of the lease extension shall require that the state receive fair market rent for the extension period as determined by an independent appraisal. Revenues generated by DLNR from the lease extensions shall be to support, as I said, the OHA's 20%, DHHL's 30% for former sugar lands, and the rest go into the SLDF to support the department's mission and resource management and protection programs.
Representative Tarnas, I'm sorry I have to stop you soon because your 5 minutes are up, and we want to be sure that Representative DeCoit can speak before she needs to leave. But I'm sure we will come back to you.
Real quick, 2 points.
Okay.
It's essential that any decision about these lease extensions must be made through a public meeting, properly notified before the Board of Land and Natural Resources. So everyone will be able to review and comment on these proposed lease extensions. And this is not a mandatory thing. It's just authorizing DLNR to be able to make these extensions. And last point is that HB 499 does not apply to lands approved for the use for housing for Native Hawaiians. So I will stop there. There's more to describe. This is a complex bill, but with that being the only time I have, I'll return the floor back to the moderator and be ready to continue at a later time. Thank you very much. Mahalo.
Thank you, Representative Tarnas. And now we will hear from Representative Lynn DeCoit.
Hi, aloha and mahalo, everyone. First of all, I want to aloha the Democrat Party of Hawaii and the Hawaiian Affairs Caucus. This has been a trying year for most of us. And with all due respect to, of course, Representative Tarnas, this was a long worked on bill. But I do have my opposition behind this bill. Again, I feel, we have a trust factor here with DLNR. Well, a lot of these stuffs are put into a bill for the reasons said. There's always amendments along the way that have always changed the dynamics of it. We talk about the funding mechanism and revenues that are generated. One, we continue to extend out on some of these extensions of the different uses. But really, when we look back at the wrong and that we try to make it right, you're talking stolen lands. You're talking lands that really need to generate for Native Hawaiians, for the beneficiary of the public land trusts. If you look at the lease extension in itself, you're looking at an extra added 40 years of lease extension, and this is based upon approval. So if we have the leasee and the leaser that are actually having this conversation, wants to think, where do we go from that? It's nice that we have the public comment, but I mean, HB499 is a complicated bill if you really don't dig into the depths of what has happened prior. One, we have BLNR that still needs to fulfill its fiduciary obligations, best and most appropriate uses of these lands, subjected to the public trust and land trust. You have Native Hawaiian lands, even within the Department of Hawaiian Homelands. And as we saw, there were many of my colleagues that have worked really hard trying to find options for us as Native Hawaiians, whether it be affordable housing. And I'll just slide this right over to Senate Bill 2, trying to transfer 100% of those ceded lands into affordable housing into an entity that now allows for 30% of those lands to be used for affordable housing for Native Hawaiians. You get $100,000 and then you tell yourself, I'm going to give you 30,000 and I'm going to use the other 70,000 of your own ceded lands now to be put to the task. To tell me at this time that, but you don't understand because we got to build homes for Native Hawaiians and beneficiaries. Well, that's not a problem we're dealing with there. We're dealing with that problem in the Department of Hawaiian Homelands, yeah. So the compilation of HB499, the compilation of Senate Bill 2 has good things about it, but the underlining of it is what is the trade-off here? I have an issue with the bill. My trust within the department has fallen very short in the past several years. While opposition and heavy opposition of the areas that I represent, which is District 13 of mostly Native Hawaiian and rural areas, have been subjected to basically falling on deaf ears. And again, I gotta give Governor Ige kudos because even when it came to funding DHHL under operations and administrations, it was the governor that stepped up when the House could not come to an agreement in funding operations and administrations under Castanetti's decision. So my kudos to Governor Ige, but going forward, as we looked at the major opposition here, the extensions out of the 40-year lease from 65 years, we have to understand that the pro rata share, even within OHA, is also subjected to an audit that was also done, right? And making that wrong, right? On how those funds were used, because we saw with many areas that there was a cry out of how these funds were being really applied. But I look towards all of you. The process of testifying and testimony was huge, stated in most of it was justifiable. And now we look towards Governor, and I know Governor going forward, he's going to look at what's the best for everyone. And this process that you folks have, the engagement behind the Democrat Party and also the Hawaiian Caucus, I want to mahalo all of you, and I thank you for having us to have discussion here in Kuka. So mahalo to the caucus and everyone that has joined us tonight. Aloha.
Mahalo, Representative DeCoit. Now we will hear from David Kawila Copper of the Native Hawaiian Legal Corporation.
Hi, thank you, Mona. And I do want to make sure that everyone has equal time. I mean, it seemed like Representative Tarnas may have had some further points. Do we have time to maybe allow him to finish that?
We probably do.
Okay, great. Representative Tarnas, if you had further points, I don't want to just cut you off.
You can use a couple of my minutes.
You go ahead,
Just
and
being
I'll
cautious.
circle around back. So you go ahead. Kavika, go ahead.
Thank you, and thank you for to the caucus for having Native Hawaiian Legal Corporation here. This is a really important issue, one that I've been involved in for some time. And I also appreciate this open forum and exchange of information. I see the toll of litigation and what it has on all parties. So this is great that we have this sort of cordial sharing of information and differing perspectives. That said, I do have concerns, and this is not with the intent of the bill. This is with the effects of the bill, some of which may have not been considered, or at least which I'd like to highlight. And my first concern is that we really do have really the risk of creating a lasting legacy of the long-term leasing out of our state trust lands and resources. And I wanted to sort of focus on what this bill does and what it applies to. It does apply to all commercial, industrial, resort, and government leases issued by DLNR and the DHHL, which are both now in existence and which will later come into existence, really in perpetuity. And according to the public records I've seen, that is approximately, this is conservative, 222 DLNR state leases, 123 DHHL leases, that's 345 leases total. And I don't think we can look at the total acreage or percentage of the total land trust inventory, because these are the leasable lands, right? These are the lands with commercial value. And they can be leased for 65-year terms. They often are. And we should note that that really is not the industry standard when it comes to commercial leases, right? Because the landlord will not have the opportunity to adjust the rent, to open up competition as the market changes, as the surrounding context, neighborhood changes, to adjust. And COVID has really taught us, right, that we can see a drastic and dramatic change in how we live and interact with one another overnight. Climate change is a real reality. So having flexibility is critical. It is part of being a prudent land manager. And we already have this issue with having long leases. And so we already see with 65-year leases that tenants may feel entitled to a lease extension. Well, what happens after 105 years, which could happen under this bill, or if the lease is perpetually extended, we still have that. And what does that look like? Well, it would be difficult for the state to get these lands back. They're gone like a sale. And as Professor Mackenzie already went over, our legislature already spoke on how sales are disfavored and require a 2/3 majority vote to sell these lands. And I think we can get behind the goal of helping small business, helping specific businesses. And we hear the argument that, well, these agencies do not have to use this authority. They can use their discretion. But, there's always the risk. We know administrations change, right? But there is no sunset clause. There is no, guaranteed change to this law. It will be there. And if there's a potential for misuse, we have seen that, unfortunately, it has happened, regardless of the intent of the legislation. We've seen lands leased for $1 a year. We can all recognize mismanagement of Mauna Kea, historic permitted taking of state and DHHL lands, waters in East Maui being perpetually disposed of under the guise of temporary permits, right? So if there's a possibility of that happening, we've seen it happen. And we need to be prepared for really a tidal wave of lessees looking to lock up long-term leases, because now there's the ability to do so. And that's the lasting legacy of this bill. Another thing to look at is does this incentivize and reward bad tenants? And I think that is a real possibility here, despite of what could be, a really positive intent to assist, a few tenants to obtain financing to maintain their leasehold. And I know the situations that are often raised for this are like the industrial areas in Hilo, which have fallen in disrepair towards the end of the lease. But we could see that this does not fix the problem because we are merely extending the lease. At the end of that extension, there will be more disrepair. If we step back, we should think that what are the qualities of a good lessee? They upkeep their property, they upkeep the lease. And often in these government leases, including, this is a term of the lease, right? They need to take care of the property. And if it is not a term in the lease, at minimum, just like the Pohakuloa case that Professor McKenzie brought up, the state does have a trust duty to ensure that these properties do not fall into disrepair. So really, these lessees are already incentivized to upkeep, because if not, they could lose their lease or at least have an unsuccessful business. If they are great tenants, well, they could have a good chance of getting another long-term lease. So really, this would be rewarding bad behavior by extending leases. If property is in disrepair, the lessee can use the disrepair as a leverage to ask for a lease extension. And where leases, hi.
I'm sorry, I have to interrupt you. You've reached the 5-minute time limit. And we'll go to our final speaker in the presentation session, but we're going to open it up and go back to Representative Tarnas and open it up for questions. So thank you, Kawila, for your presentation. Now we move to former Governor John Waihee III.
Thank you. I thought that we were going to give Representative Tarnas some additional time. But let me begin by saying that this may be a case for me that matches a couple of old sayings, like there's no good deed goes unpunished, and you know your sins will find you out. Since I've been involved with this question from its inception to its till today, in a sense, when it comes to dealing with ceded lands and sales and the like. My problem with the bill is that this is what I would call a trust me bill. It's a bill with ostensibly good intentions, but you have to trust that those intentions would be carried out. And I think that's kind of what David was talking about in his discussions. Let me put that more into context. I think that the prior speakers have pointed out the importance of the ceded lands question, the idea of the public trust and the rest. So as is the case oftentimes with any kind of legislation, with any type of public policy, one is involved in a kind of a balancing analysis. You have, in my opinion, a very compelling public policy dealing with ceded lands. So what would be so important that it would overcome that policy? And when I looked at this bill initially, and I thank Representative Tarnas for clarifying some things, because when I first saw this bill, I couldn't figure out who the bill was for. I mean, why would we give this kind of authority to DLNR? Who is it for? And when you look down the list of possible lease extensions, we talk about, for example, commercial leases. The largest commercial leases that I know of reside with Hawaiian Homes in like the shopping centers in Hilo, for example. And so why would you give DLNR the ability? Now, some lawyers may argue about the Chapter 171 and the like, but the point is, DLNR has, Hawaiian Homes has a whole different additional set of beneficiary concerns that may be included before they extend leases for 40 years. If you look at industrial uses, who are these industrial uses? It's we talk about probably the only one that can come up with might be Sand Island. And Sand Island, there's an obvious case and a good case, I believe, a compelling case maybe to look at a new leasing arrangement for Sand Island. And while you're doing that, take a look at agriculture, which is not mentioned in here at all. One of the big problems with the state leases on the agricultural parks is that oftentimes these agricultural leases end up going to gentleman farmers instead of real farmers. So maybe you need a criteria that targets the specific people that you want to help. And that's my problem. So the only thing left in my mind, you talk about, well, what would be so compelling? When the whole issue on ceded lands came out, the compelling state use was housing. This will not be used for housing. I don't know a single government lease for housing development. And even if you did, who would you be extending the lease for? Would it be for the developer or for the current owners of the house? I mean, these kinds of issues, when you actually go into the bill, start to pile up. Now, I know the representative has said that these provisions would not be used to extend the leases at Pohakaloa, Makua, or at Barking Sands and other places like that. And yet, what government leases are there for government uses that are not military? What are they? I mean, the only ones I can think of, they might be a charter school someplace on state land. They might be somebody on a museum. They might be a nonprofit someplace. The point I'm trying to make is that the danger with the bill is that there is no clarity on the public purpose that is being served that would overcome the public purpose that is clearly established by the way we manage our trust lands and our and ceded lands within our state. And so if you're going to pass a bill like this, I think you need to be very clear on who the beneficiaries are and structure the bill in the way that benefits the target. The people at Sand Island might be better served by a bill that says Sand Island will be extended for 40 years that meet certain small business criteria. Same thing with small farmers. And I just recently ran into the governor and I talked to him about this. And what he told me was that the DLNR actually had a bill that was very specific and targeted to people that would be in these categories. And it didn't get a hearing. So my worry is, is this whole trust me thing. Now, I'm not going to say that that's not a good approach. We built Kapolei with Trust Me. We were building houses in Maui and on the Big Island with Trust Me. Those are what caused the Supreme Court cases. But in my opinion, every public policy analysis begins with knowing what important issues are being undone for what important objectives. And in my mind, it's not clear. If we're going to help Sand Island, we should say this is a bill for Sand Island. If we're going to help the industrial park in Hilo, that's what the bill should do. So anyway, that's my position, and that's why I am recommending that it be vetoed.
Okay, mahalo, Governor Waihe'e. What I'd like to do is go back to Representative Tarnish at this time. I'm thinking 5 more minutes to finish or say more and maybe respond to some of the speakers if you'd like to. And then I'd like to, Representative Decoit is still online, so I'd like to give her and Kawila also a time to engage in more discussion. And then we'll get into our questions and answers. If that's okay, let's proceed with you, Representative Tarnish.
Hello, I appreciate the opportunity to participate in this conversation. And, you know, I think it's important that we recognize that, I emphasize that my goal is to actually help DLNR do a better job managing its leases. Because as you mentioned, you know, we need to have these leases so that there's regular review of the lease rents. There needs to be increases in lease rent. We need to make sure that the lease is being properly taken care of. Investments in infrastructure take place so it doesn't get run down. That's lease management. And DLNR needs to do a better job in lease management. There was an audit done of the lease, land division and the Special Land Development Fund. And we actually formed an investigating committee in the House to follow up on that audit, those recommendations, so that we can make sure that DLNR improves the way that they manage their leases. So they certainly do need to improve those. I want to emphasize in the bill that it's very clear that if there is any extension, that it's for 40 years maximum. So this idea that this would go on forever doesn't comport with the language in the law, in the bill itself. And again, I wrote this, the bill was really focusing on DLNR. So that's how we focused on Chapter 171. Because DHHL uses Chapter 171, they would also be able to do this and utilize this. But in statement from Department of Hawaiian Homelands, they made it clear that any of their decisions about leases has to be in consultation with beneficiaries. So I emphasize that we all have to continue to participate in the process, whether it's with the land board in their decision-making process, give input on that, comments, suggestions, whether it should be approved or not. And the legislature needs to provide oversight over DLNR. DHHL, the same thing. We need to make sure that what beneficiaries are actively engaged in any of the decisions that DHHL makes about their leases or their lease extensions. I want to mention that, you know, in terms of educational leases that the state provides, it's for a wide variety of uses. University of Hawaii, Manoa, University of Hawaii at Hilo. We've got Honolulu Academy of the Arts, UH Community Colleges, Hawaii Pacific University, Ka'ala Farms, Arc of Hawaii, Haleakala School. I'm just reading off of the list that we can all look at if you want to go to what the professor had mentioned to us, pltis.hawaii.gov. So there's quite a variety of educational leases that the state does provide. And the bill was written so that it would apply not just to industrial purposes and lands and leases like at Sand Island or in Hilo, but it would also apply to the other land uses that we've discussed as well. Commercial, resort, mixed use, and government properties. Government properties could also include counties. Now, I understand there's a trust problem with DLNR. And I take it as part of my responsibility as the Water and Land Chair is to provide oversight on DLNR and make sure that they are doing a good job. And that's part of what we have to do with this investigating committee that I'm working on during the interim. And we will follow up on the recommendations of the audit of the Special Land and Development Fund. And that includes their lease management of the land division. They're not perfect. I recognize there's a history of problems there. And so I take that as part of my responsibility is to provide oversight and make sure that we can do everything we can from the legislature to improve the operations at DLNR. Perhaps I should leave it at that and then I'll turn it back to the moderator so we can.
6399201. Yes, you can call me later.
Okay, thank you, Representative Tarnish. So I'd like to give Representative Decoy and Kawila Copper, would you like to say anything in response to what has been said? And then we'll open it up for questions and Governor Waihee as well.
So thank you, Mona, and thank you for the prior speakers. I just want to add that, what we're offering here is, again, something that is not in the best benefit of our Native Hawaiians and our beneficiaries. I agree with what Governor Waihee is saying is, what is our target? We have a bill before us, which I have my concerns. We have had several other bills that have been counter of what we've actually tried to promote, whether it be DHHL and trying to bring that wait list down, whether it was the prior water bills that have come before us. And as we saw, major changes were back and forth. And again, bills are always there to be amended, which it has. If we're gonna start someplace, let's start at trying to correct what has always been said by many of us. What is the benefit here? And the trade-off is really the killer for most of us, because again, we're trading off percentages here under negotiations. And when you look at HB499, we're gonna wait 10 years for renegotiate this lease. We saw earlier, which Melody, thank you for the presentation that you did. Some of these leases are 65-year leases, capitalization behind of them. Part of some of these leases, I believe Ala Moana Center is sitting on this. We get high-end people in there, and yet we get on $1 a year $1 for 65-year leases. There's other leases even within the Department of Hawaiian Homelands that are subjected to extensions. Let's not forget the 99-year lease that is about to be up that have not been extended there. So, I have my concerns with some of the departments, but where's the trade-off here in the benefit of beneficiaries? And, I appreciate this forum because I think it allows us to bring a lot of light. Native Hawaiian Legal Corporation, even when Mahealani guys were there, and we fought the water battles. I mean, these battles have been ongoing. Again, as Governor Waihee has said earlier, we now have to also consider ag lands. And I brought this up earlier with Juanita. Some of our ag lands, even within the state of Hawaii, as we've seen, we talk about important ag lands. Now let's lift that shield up and say, if your lands are important ag lands, what is the underlining? Those important ag lands, and the state has not dedicated their own lands as IAL lands. It's because IAL land designation gives you free access to water. And I have a problem with that, because we should also make sure that those that are on Native Hawaiian lands, in this case DHHL lands, should have their own fair share of water, whether it be through agriculture, as Kuhio has envisioned for many of us under rehabilitation. So, I'd like to leave it at that because I know there's a lot of comments and questions, and I do have to leave, but I just wanted to say mahalo. I think the kuka is great. I think going forward, this thing, the bill in itself, consider working on this. The recommendation is the veto at this point, and I think there's just cause behind it. Yes, there is a major trust factor here for me within the department itself, but I wanted to mahalo everybody and thank you for joining us tonight. So thank you, mahalo.
Thank you, Representative Decoy. Kawila, I want to give you another opportunity to talk, and I want to start this first question with you. So go ahead and say what you'd like to say, and then I'm going to give you the first question.
Okay, thank you. And I'll just come right out the gate. So first, I've seen questions on repeated extensions. A single extension, true, cannot be more than 40 years, but nothing in the bill restricts repeated extensions. One big point is really there's no need for this bill at this time. There actually is a pilot project for much of the areas that have been raising concern in Hilo, including Banyan Drive and the Kanoilehua industrial area. It was enacted in 2018. It's a much more robust framework, barely underway. And its point was to see, does a lease extension result in revitalization of dilapidated areas or areas in need of updating? So we can wait and see if that will work. And we know that the majority of the leases at issue are not going to expire anytime soon. We at least have another year to work on this. And I know myself and other members of the community are open to working on a better bill, because Representative Tarnas is right. There are issues with the laws about land management and leasing for DLNR and DHHL. And it's not limited to this one issue. So we can address that, and we should address all of those issues. One thing before I close, and then I will close and wrap up for questions, is issue of Mauna Kea. Now, the bill does not say that it does not apply to Mauna Kea leases. It exempts the University of Hawaii, and we all know there's been talk about moving management of the Mauna to another agency. Well, then it's very likely this bill will apply, because of course the bill applies to government leases. Now, just to close, I do have to bring up something that I personally am struggling with, and this is just, it's a me problem, not a you problem. But as a Native Hawaiian, but really primarily as an advocate for the Native Hawaiian community, I do believe I need to discuss this issue in terms of general management and public interest and leases and landlords, because really my experience tells me that this is the only way that we can have a conversation on it. But as the other presenters have recognized, this truly and really is a Hawaiian issue. Hawaiians do have a recognized claim to these lands, and they're supposed to be used for the betterment of their condition, at least until these claims can be reconciled. And there has been years of litigation over this. Overwhelming feedback and testimony of this bill has been negative, largely for this reason. And so, what message does this send? And again, I'm saying message, not the intent. Well, to the 30,000 Hawaiians still on the DHHL wait list, and the state fights back in order to sufficiently fund them. OHA has not had a proper accounting of ceded land revenues in years. We have Hawaiians, 500,000, many of whom are asking for reconciliation or recognition or sovereignty or something, right? And collectively, this has got to be the largest constituency, yet we never see these same efforts to radically change laws, to fast track procedures, to exempt statutory restrictions, for this community, for these people from whom the state have taken so much and benefited from the land, culture, and heritage. And so, yes, I think this is part of a larger problem, not related to this one lease, but what does this send to our community who do not see the same benefit and who year after year have to speak out on issues of concern like this? Thank you so much for hosting this forum and for everyone here.
Mahalo, Kawila. I'm going to throw this first question out to you. This we received by email. What is one of the most scariest consequences that a measure like House Bill 499 could have if enacted?
A great question. And I think I'll go back to my first point, is really the lasting legacy of the long-term leasing out. And Governor really brought up a good point. The trust me sort of statutory frameworks do not work, because we may trust the people in the room, the people in the big buildings, but those people change. And really, when it comes to land, we know how valuable it is here in Hawaii. And so if there's a way, technically, legally, to get these lands locked up, people will do that. So that, to me, is the large concern, the possibility of this bill, which could be in effect for many, many years and generations.
Thank you. Next question is for you, Representative Tarnas. Considering that at least one of the developers, Prince Kuhio Mall, who supported this measure, was looking for lease extensions for their lease of Hawaiian homelands, was there any attempt before writing this measure to consult with Department of Hawaiian Homelands?
This measure actually was written, I reintroduced a bill that was written previously last year. Representative Chris Todd had introduced it, and I reintroduced it again this year. I don't know if he had discussed it with Hawaiian Homelands, but when I talked to William Ila, he said they were not advocating for this bill. They did not submit any testimony in support of it or against it. They already have the ability to extend leases And so they were not asking for this. And they said that they may not even use it because their whole effort needs to be they have to consult with their beneficiaries. So that was what Chairman Ayala had mentioned in his public statement about this.
Okay, thank you. Governor, this question is for you. If you were still governor, would you veto this measure? Why yes or no?
When I was governor, I passed a lot of these bills. So, so let's, we, as I said, we did a lot of things for it. And what I learned over the years is that somebody else reading the same bill may not see it the same way. And things that we did, somebody else disagreed with and went in a different direction, and it resulted in the lawsuits that we now have regarding ceded lands. My problem with the bill is that, especially with regard to government uses, the types of uses that you would want to continue or extend may need a different kind of criteria than just fiscal. And this bill is built really for somebody in the business of business, so that there would be somebody who has a lease that's willing to put a 30% value investment in it for 40 more years. That's not going to be a little charter school someplace that's doing a government use. That's not going to be all these little farmers that are struggling to stay alive. So if we are going to pass a bill that gives flexibility for leasing government lands to enterprises, then we ought to know who these people are that we are in fact helping. It may be that you need a bill that extends a lease, but that you may need a bill that changes the bid system, so it's not always the highest bidder who gets the lease. It might be the person that spent the most time and effort and years on the land. See, this is what I'm talking about. The problem with this bill, it's a trust me bill, it's an economic bill, and it's a bill that the lot of the tiny people that we are ostensibly trying to help probably could not afford to do. So who are we doing it for? I would veto the bill.
Thank you, Governor, for your response. The next question is a long question. It's for Representative Tarnas. And so I want to give Ken Farm a heads up that we'll go to questions in the chat box next. So I'm hoping that you can raise those questions for all of us. Okay, so this question, Representative Tarnas, as one who submitted this bill, I am assuming that you have done due diligence on the background of this bill. Many scholars like Donovan Preza, Kamana Beamer, Umi Perkins, and even John Van Dyke have shown that the crown lands of the Mahele were the private lands of the king. When a government is overthrown or changes, it does not affect any public lands. For example, now that Donald Trump is no longer president of the USA, Trump Tower still belongs to Donald Trump. Do you agree that the crown lands do not belong within the ceded lands category and should not be included in House Bill 499?
All I know that this bill applies to the public land trust, and so it doesn't make any distinction between anything within that public land trust. And so I have to go with what the language of the bill actually says. So that's what we have to work with, are the words in the bill. And I want to emphasize again, this I reintroduced a bill that was introduced last year. So I built upon the work of previous legislators who had worked on this, and the genesis of the bill really came from Hilo. Representative Todd, who developed the bill, introduced it previously. It was working on behalf of small businesses who were very willing to put in 30% of the value of the lease into improved investments on the infrastructure. And these are small businesses. So there's not big major corporations. These are individual, small, family-owned businesses that are very more than willing to put in that kind of investment and make that kind of commitment in order to get an extension.
Thank you, Representative Tarnas. Now I will open it up to Ken Farm, our other moderator, to give us some questions from the chat box.
Thank you. I'm just trying to find some of these questions. And again, thank you, Representative Tarnas, for being here and meeting with us. I have one here. It says, Rep. Tarnas and the others who voted yes on HB 499 seem to have been aware of all these issues that are being presented today. My question is, why was HB 499 still passed in its current form?
I recommended approval and the House Water and Land Committee passed it. It went on to the next committee, they passed it, went to the Senate, they passed it, and went through the legislative process. So it wasn't just me. I was the chair of the first committee. I was one who introduced it. But legislative action is a very collaborative process. There was many people that had a chance to review the bill and vote for it in committees. They could have amended it in committee. And so what we have before us in the final draft of the bill was a result of many legislators who had lots of opportunity to amend it. And what we have is the result of all that. That's just the legislative process.
We have another question here. How do you expect, and probably not just for you, but I think it's for everybody, can chime in on this one. How can you expect DLNR to do a better job when basically the bill gives them the power to give out leases?
They already have the power to give out leases. This bill authorizes them to extend the leases. And how do we expect DLNR to do a good job? We have to hold them to a high standard. And the audit that was done a couple of years ago pointed out problems. And as I mentioned, the House formed an investigating committee to follow up on the recommendations in that audit so that we can really hold the DLNR Land Division accountable and make sure that they do improve the way they manage their leases. And so I take it as a part of responsibility of my job is to provide that oversight on DLNR, their land division, and look at how do they implement the recommendations of that audit so that we can improve it.
And to dovetail with that, there's a question here. How qualified is DLNR to make these extensions? And what is their main mission statement, I guess. But I guess it's more, how qualified is DLNR to make these extensions? And you can say, Rep. Tarnas, and I can also have input from the other members as well as what they, other members of the forum.
They're qualified. That's their job. They were hired to do it. These are professionals that do this work. I get it that people are upset with DLNR. They don't have trust. Some people think that they aren't doing a good job. And I appreciate that. And that's, like I say, part of my job is to provide oversight to try to get them to do a better job. Governor, you were in the business of running the executive branch. What do you think?
No, I agree with you. I don't have, actually, Representative, I don't have very much problems which are perspective, because we live with what we got. And that, in a sense, is we got the government structure, and we have to depend on them to do their jobs, and sometimes they don't. So I agree. In fact, I even think that I'm hoping that even if the governor vetoes this bill, I'm hoping that you produce a bill that helps Sand Island and helps small agricultural farmers and the rest. The problem is not just DLNR, it's the way that human interaction takes place. As long as David Tarnas is there as chairman of the committee, I might even feel comfortable with this particular bill because of your own sincerity. But you may not be there 2 years from now. And we know definitely this governor won't be there 2 years from now. So who will be? Professor McKenzie and I structured a claims panel for Hawaiian homes beneficiaries who had been damaged by the actions of the Department of Hawaiian Homelands. We thought that was going to be still functioning maybe till today. But what happened is that when I left office, within a short few years, none of that got funded. So my problem with the bill is not the objectives. In fact, I believe in those objectives. I think they mean something. But it is in the structure of a bill that gives as much discretion as we have to human beings. And it's not just DLNR today, it's to the fact that we don't know what the people 10 years from now are going to think about any of these issues. And that's the problem. I don't know if that answers the question, but.
I'm going to do a round robin here. So I'm going to start with David. David, did you want to say something about that? But I was going to also start with you with another question.
Sure. Yeah, I would. Thank you. You know, I recognize the harm that can happen to public trust, like confidence in our government if all we do is sow doubt, you know, and cast judgment on our agencies. But sometimes there is a use for that. And we've seen DLNR's judgment, you know, historically been put and repeatedly put into question, even when it comes to other leases. I've recently Pohakuloa. So yes, oversight is required, must be mandatory. Having the right people in those agencies with the right perspectives, Hawaiians in those agencies, experienced land managers in those agencies. And then yes, taking a hard look at DLNR's authorizing statutes, re-looking at really, is the long-term lease program working? Is 65 years really prudent land managing? Shorter leases, but long enough that the lessee can obtain funding with built-in possibilities for extensions, with, you know, for good lessees, good behavior, maybe that's a possibility. I don't know. That's something that we can look at as well. But trusting DLNR, I'm not even sure that they have the right tools, you know, the right laws right now to fulfill their obligations.
So David, I'm going to start with you again here. This is a different question, and then we're going to just round robin this. So it'll be David, Representative Tarnas, and the governor here. And if you wanted to chime into Mackenzie, you're more than welcome to. Melody it says the Hawaii Supreme Court has declared that the public land trust is like regular trusts and that it has beneficiaries and that the beneficiaries must have benefits. How does HB499, among other things, protects the resources of the trust and provide benefits to the beneficiaries? In this, it's saying the betterment of Native Hawaiians and the general public.
I don't know that it does. And, you know, I brought up the pilot program, which includes, you know, other users of public lands, agriculture, pastoral, you know, growing food, which, you know, during COVID, that's another important use of our trust lands, of any lands here. It is a more robust program. And again, you know, I think in order to protect these public trust resources, longer leases are not the answer. Smarter leasing, smarter management, and taking a holistic look at the whole program is the answer.
You know, I absolutely agree. We need to have smarter lease management. And that's why I said, you know, I have to really exercise my oversight responsibilities on this investigating committee to implement the recommendations of that audit, because they do need to be held to a higher standard. But the land division and the land board, they really have been entrusted with public lands, and they have a fiduciary responsibility to manage that trust solely in the interest of its beneficiaries, the people of Hawaii, Native Hawaiians, and to deal impartially when there is more than one beneficiary, and to use reasonable skill and care to make that trust property productive. We have to hire the right people in these jobs in the government, and then provide oversight, supervision and oversight, and have accountability. And part of the job of the legislature is to provide that oversight of the executive branch. You know, we have these separation of powers, but that's part of the way that we work with each other to try to have us all do the best job possible. You know, we're all human, and I appreciate the governor's, you know, acknowledging of our human foibles, but we are a government of humans with all of our flaws. And so we do need to help each other do a better job. And that's part of what I really want to do in trying to get the DLNR and their land division to do a better job.
Guess one thing that I would say, I mean, I totally agree with what Kawila had to say, but I also think, you know, that Act 149 was passed in 2018, that pilot project. So I just don't understand what is the rush now to pass this bill, to get this bill signed, when the pilot project is still, you know, young. It's an opportunity to see how well it works to give lease extensions. And that was the whole purpose of the pilot project. So it seems like, in line with the idea of having good management, that following through on the pilot project, seeing how it goes, what we can learn, positive and negative, before you take the bigger leap to something like Bill 499, seems like the better and more prudent thing to do.
Governor?
Yeah, no, well, ditto. I mean, everybody's making, these are all good points. I think, though, if I was going to make an additional point, one of the problems with the government structure and a broader issue of it and the Lahui is the fact that the structure was not made to inherently incorporate Native Hawaiian values. And so a lot of the, not just this bill, but a lot of the tension, a lot of the discussion, a lot of the journey that we need to go through as a state is to adjust in a way that does that. I mean, you know, it's so, in the Western system of looking at governance, since we're talking about process, that is it. If you set up the right process, then everything is fair. So if you send people to a hearing on Mauna Kea and everybody listens to all sides and makes a judgment, it must be right and fair. One of the underlying issues that we as a society, and I don't want to get too airy-fairy, but one of the underlying issues that we as a society need to deal with is the fact that there are people who believe that the result is what states the value and not necessarily the process. So you can tell somebody, you know, as many times as you like, that we've had hearings, we've done this, we've had discussions, but if you come out and you pollute the Aina at the end of it all, doesn't make sense. And so that tension, that incorporating the thought, the value systems of the Native Hawaiian community, I think, is one of the background problems behind the discussion of this bill. It may not be anything to do with the objectives. It may not be anything to ultimately do with the process as much as it is to do with the fact that within the value system of at least that segment of the state's community, there is a difference of what is valuable. And I don't know, and I don't want to, you know, belabor that point, but I think that's there's a problem. There's an inherent problem in the processes of government that it's going to be our privilege to work through.
So I'm going to let whoever wants to jump in first on this. Is another question, and this is relating to, since Rep. Tarnas, you're talking about resorts, and you know, we've seen, you know, resorts as it was that have become resorts with, you know, a amount of individuals that work there as employees, but then as it becomes timeshares, for example, they reduce their staff. Now, when we're talking about being locked in, you know, as part of these leases, was that kind of taken into consideration? What would happen if, you know, let's say they had 400 staff or so, and now they need 1/3 of those individuals less. And those are people now the state has to deal with in terms of unemployment, job training, you know, all those other things. Was that, you can start if you want to, just was that kind of thing was factored in?
I did not look at any individual project and the, you know, change of it's really, it's the land use itself is resort land use. So that's the purpose of the lease itself. And I think in any evaluation of either providing the initial lease or an extension, DLNR has to do that kind of discernment to determine, is this in the public interest? Is this actually provide the best return to the state government and to our beneficiaries of the public land trust? The legislature, recognize that the executive branch needs to execute this. They need to implement it. They need to do that discernment process and the due diligence. I didn't evaluate individual leases for resorts to decide whether this is appropriate to use in here, because I think that's what the executive branch has to do. Governor, that's what all your people did when you were running the place.
And believe me, I trusted myself, but very few others. No.
We have one.
Ken,
Oh,
if
go
I
ahead.
might, I know
Sure.
we're running out of time, but I do want to mention there's some really broad issues that we've been talking about here, and I want to draw everyone's attention to another piece of legislation that I was working on. We don't have time to talk about it tonight, but it's a House Concurrent Resolution 76. I would really urge you to take a look at that. What it does is I was in the legislature 25 years ago, and I served for a couple of terms there. And back then we passed Act 14, which was a settlement of the land claims made on behalf of Hawaiian Homelands Trust against the state between 1959 and 1988. And I don't think that we've completed our transactions under that settlement. So I wrote this resolution to do an evaluation of that to make sure that we did fulfill our full settlement under Act 14. And so perhaps this is a topic for another conversation.
Time. I think I did have to bring.
Yeah.
I'm going to bring out this. Go ahead, but I have one other question I need to ask. The last question.
Well, I just want to say, and that's what I was referring to, Representative and others. We may be having a discussion that is the tip of an iceberg, yes, actually, about what is really at stake, and it's not any particular individual's fault. It's just something we need to deal with.
Yep.
Well, it is somebody's fault. It's the fault of people who overthrew Liliuokalani, but I'm not getting into that.
So for the closing question, this question is, there's some thought that maybe this is too broad for dealing because of everything they have to deal with as an agency. Maybe there needs to be an agency that's established that's devoted only to public land trust. What are your thoughts on that? Anybody wants to start?
I'd like to mention, I think it's a great idea. We don't want to create a new department. That's a challenge, to create an entirely new department. But I do think that DLNR is got some conflicting missions. Here they are, they're trying to manage the public land trust and make full use out of it, but they're also responsible for conservation of natural resources. Sometimes those come into conflict. And so that was one of the reasons why we passed 2 bills this session, which was we actually moved the Land Use Commission into the Office of Planning, and we moved the Office of Environmental Quality Control over to the Office of Planning and renamed it Office of Planning and Sustainable Development. That's a first step in what I foresee as a long, methodical process to try to figure out a way that we can restructure our state government so we can integrate our sustainability principles into our land use decision making. And so I think it's a very relevant question, Ken, and I think that's certainly going to be a topic I'd like to pursue in future legislative sessions.
David or Melody, do you want to add anything about that? And then we'll close it to you, Governor.
No.
Since I'm unmuted, I'll say, that has to be part of the solution. That we know it hasn't been working. It needs to be decided by those with an outstanding interest to these lands. And I think that is definitely Native Hawaiians, whether it's part of this process or another, has to be a part of reconciliation and resolving the issues with these lands.
I have 1 minute left. Governor, do you want to say something, or Melody, do you want 30 seconds of that?
I'm good.
Okay.
Oh,
You have a minute.
well,
go
well, Melody, she can say, well, here's my minute. I think that, reconciliation is the ultimate backdrop to all of these discussions. And that no matter what process we set up, until people believe there is justice,
Yeah.
it's never going to be 100% accepted. And frankly, I appreciate Representative Tarnas being here and expressing his point of view. I think that's, at least we know where his heart is at, even if we don't agree with his head, you know what I'm saying? So anyway.
Well, I want to thank all of you. So my time is up for this part over here. Thank you for doing this round robin. I will turn it back over to Mona. Mona?
And I will turn it back over to the chair of the Hawaiian Affairs Caucus, so Juanita Kawamoto Brown, or Brown Kawamoto.
Mahalo, everyone. I am so thankful that everyone is able to come together. The discussion was incredible. So much information that was so purposeful. And so I think that the whole thought of, on behalf of the Hawaiian Affairs Caucus, we just want to mahalo all of you for participating, and for the audience's participation in the great conversations that were had today. I think we move one step closer to solution with such wonderful people in the room. So mahalo, mahalo, mahalo. Thank you.
Mahalo to the organizers. I appreciate being here and being part of this conversation. I look forward to future opportunities.
Thank you.
Thank you, Representative Tarnas.
Thank you, Representative.
Thank you, Gov. Thank you, Melody.
Thank you so much. Mahalo.
Aloha.
Aloha.
Mahalo for
Aloha.
speaking.